Good morning, everybody, and welcome to our November Legacy Loop. It's great to see so many of you here. This month, we're running a joint session with the Institute of Legacy Management. So for those people who are members of the ILM, if you don't know about Legacy Loop, it's our monthly space for charities to explore, learn and connect on everything about legacies. Today's session is focusing on GDPR and data retention for legacy fundraisers. At Makeable Online, we support charities with a solicitor check will writing service, detailed reporting and supporter engagement tools, all designed to make legacy giving easier and far more effective. So if anybody who's not already a charity partner wants to know more about our end-to-end service, then do get in touch with me. Just a bit of housekeeping. It would be great if you could add your charity name onto your name tag and put any questions that you have into the chat. There'll be time for questions at the end of the session, so we'll make sure that they all get answered. So let's get started. So today we are joined by Hannah Lyons, legal specialist in data protection and fundraising at Bates Wells, Matthew Lagden, CEO of the Institute of Legacy Management, James Stebbings, chair of the ILM and also head of legacy and income at Macmillan Cancer Support, and Oliver Asher, who is founder of Makeable Online, solicitor and head of legal. So over to you, Hannah.
Great. Hi, everyone. It's great to be here. Thanks for inviting me today. So as Marie said, I'm a lawyer at Bates Wells. I'm a partner in our charity and social enterprise department.
I've got mine.
And advise charities on a range of legal issues, including data protection law and fundraising. And for those that don't know Bates Wells, we're a full service law firm, but we have a specialism in advising charities and non-profits. So before we jump into the main discussion today, I thought it'd be helpful to provide a bit of background on what the law actually requires in relation to data retention, along with what the Information Commissioner's Office or the ICO expectations are in this area. And I'll of course talk about how data retention may be applied in a legacy context. So if I could have the next slide. And then the one after that. Perfect, thank you. So you may be aware that the 6 data protection principles that underpin GDPR and tell us how data should be processed. The principle governing data retention is known as the storage limitation principle, and that's on the screen there. And that's all that GDPR says about data retention. All it says is that data must not be kept for longer than is necessary in relation to the purposes for which it was originally obtained. So not very prescriptive and not very helpful in telling us how we should actually apply that in practice. The recitals or the notes to GDPR, I've set that out at the bottom there. They do provide a bit more information and say that in order to comply with that storage limitation principle, organisations should be setting time limits for how long different pieces of data should be kept and when they will review them. But it doesn't actually say anything prescriptive about how long those time periods should be. On the next slide, I'm going to talk about what ICO guidance says in this area. So the ICO does have some helpful guidance on data retention, which fills in a lot of the gaps and lack of detail in the UK GDPR. And it's obviously really important to have regard to the ICO's guidance, as it will use this to help assess whether an organisation is compliant with data protection law, for example, if it gets a complaint from a member of the public. So the guidance reiterates that you must not keep personal data for longer than you need it. So you must be fulfilling the purpose for which it was originally obtained. And the ICO states that organisations need to think really carefully about how long they will keep personal data and be able to justify any decisions they make. And that will really need to be made on a case-by-case basis, I think. There's not really a one-size-fits-all approach, unfortunately. And a key way of setting out your retention periods and justifications for those is to have a retention policy, which I'll talk about in a minute. But the guidance says you should periodically review the data you hold and assess whether you still need it. And you should, of course, be mindful of people's data subject rights. So, for example, someone does have a right to ask you to stop processing their data or to delete it, which is known as the right to erasure. So on the next slide, I'm going to talk about data retention policies and schedules, which are obviously really key to this. And organisations should have a retention policy which sets out all the different types of records and personal data they hold, and how long they intend to keep each category of data. And that's often set out in a table or a schedule to the policy, which sets out specific time periods and the reasoning for those. What are actually the key things you need to consider in setting your policy and your retention periods? Well, firstly, and pretty obviously, you need to think about why you need to keep that data, why you might need it in the future, what use may it have to your organization. And the guidance sets out some examples. So it says you may need to keep personal data so that you have a record of your relationship with someone. So, for example, a donor or a supporter, and that's obviously really important in a legacy fundraising and administration context. And sometimes you might need to keep data in case there are complaints in the future or in order to defend a future legal claim. So that's also relevant to legacy administration. Sometimes there's legal requirements for why you might need to keep personal data for certain periods of time. So, for example, any financial information in relation to donations or gift aid must be kept for 6 years from the end of the financial year in which that donation was made, or if it was a regular direct debit, the year in which that donation was cancelled. So I think that's why 6 or 7 years has become a bit of an industry standard in terms of keeping donor and supporter data. Your policy and retention period should be kept under review, as I said, and you need to be assessing whether you need to keep certain data after a certain period of time. And the answer may be yes, but you have to kind of show that you are regularly thinking about it and not just putting your policy kind of in a drawer and never looking at it again. There's also a requirement under GDPR to inform people how long their data will be kept for, and people often include that information in their organisation's online privacy policy. You don't have to publish the full retention policy and schedule. There's no legal requirement to do that, but you must kind of provide a summary or a broad indication of how long data will be kept in your privacy policy. And I also wanted to flag that you must have a valid legal basis for processing personal data, even if you're just keeping it on a database and not really doing much with it. So, for example, a legal basis might be consent, legitimate interest, or performing a contract. I think legitimate interest is probably likely to be the most common in relation to retaining information about donors and supporters in a legacy context, but you may need to do a legitimate interest assessment to kind of demonstrate that you've done the balancing test and are comfortable that you do have a legitimate interest and that the rights and freedoms of your supporters are not being put at risk. I'm going to move on now to the next slide. Thank you, Oliver, to talk a bit more about how this all relates to legacies. So quite a few clients of mine have said that they would like to keep donor and supporter data potentially indefinitely in case the charity needs it to be able to demonstrate a relationship in the event that a legacy left by an individual is challenged. So we need to try and align compliance obligations under data protection law with the needs of the organisation, which sometimes can be a bit tricky. But I think there's various options and kind of nuanced approaches that can be taken. So I think there is somewhere between deleting lots of data, say after 6 years, which may be useful in the future, or keeping it kind of indiscriminately forever. And as we saw, the ICO guidance helpfully cites the need to confirm that a relationship existed and the defence of a legal claim as reasons for potentially keeping personal data. But it does also say that you shouldn't keep data just in case or if there is only a small possibility of ever needing it. So how do we reconcile that in practice? As I mentioned, sector standards have generally been to keep personal data of donors for kind of 6 or 7 years from the date of the donation and then delete it. But I think there are ways that you can build a case for keeping data longer than that, in order to protect future legacies. You need to be able to justify that decision. So, for example, how important are legacies and legacy income to your organization? How many do you get? What percentage of your income is it? Have you had any challenges to gifts that have been left to you in the past? And kind of what are, the wider sector position, risks, challenges, etc., which I know Matthew and James are going to cover a bit later. But there are various options that you and your data protection teams could think about. So some charities have implemented a rolling retention period kind of schedule where data will be retained kind of for a further 6 years. It kind of gets pushed on again if that individual takes some kind of action with the organisation or engages with it in some way. So, for example, if they make another donation, they sign up to a newsletter, come along to an event, volunteer, etc. The relationship is ongoing, so that justifies keeping it for further periods of time. And then obviously keeping the data of people that have told you they're leaving a legacy to you, pledged a legacy, or people that have requested legacy packs or attended a legacy event. I think that is justifiable to keep for longer periods of time, potentially indefinitely, because there's a clear indication there that that person may leave a legacy and you'd want to keep a record of that. And I think that would probably also apply to major donors as well. So people that have left larger sums to you, and there's a higher chance of them also leaving a gift in their will, even if they haven't explicitly told you that. So if your organisation does want to keep data for longer periods, potentially forever, then there'll need to be a strong justification for that, and you'd need to carefully review what data will be kept and what data would be deleted because it's not needed. So I think you couldn't just keep records in their entirety forever. You need to carefully think about, well, what pieces of data in here are essential for us to maybe potentially defend a claim in the future, but what other bits may be not necessary to keep and we can delete to show that we are thinking about this carefully. And then if you are going to keep data for longer periods, I think it's important to keep that away from your active database if you're not kind of using it day to day. So it could be archived with kind of restricted access, so only a few individuals can access it. And some charities will say in their schedules and their policies that they'll review kind of the position in relation to data retention, say after 6 or 7 years, and then decide whether to retain or delete it. So it's kind of less of a drastic cutoff. You're not saying we'll definitely delete after this period of time, but you are kind of assessing whether you still need it or whether certain data could be stripped away. Although obviously that does come with some admin and can be time intensive. So just finally, I wanted to highlight a few kind of risks of keeping data for longer periods of time, because obviously the longer you have it, the greater the kind of compliance obligations and possible risks. I've already mentioned that you need to establish a legal basis. You might need to do a legitimate interest assessment to justify keeping it on your database. Obviously, the longer you have something, data could become out of date or inaccurate, and data accuracy is one of the other data protection principles that you need to comply with. So again, kind of stripping out any data that you don't need or has become inaccurate will be important. I also mentioned that people may exercise their data subject rights over that data, so they might want you to delete it, they might object to you processing it on the basis of legitimate interest, or they could make a data subject access request. And I suppose the more data you have, the more requests you might get. Of course, data security is really important. So if you are keeping lots of data for longer periods of time, think about archiving, or maybe anonymizing or pseudonymizing data where possible. And of course, there's certain practicalities to deal with, like the cost and admin of managing your databases. So hopefully that was helpful. I'll leave it there for now, but very happy to take questions at the end.
Thank you. Oliver, do you want to skip on? I can see my next slide keeps tantalizingly popping
Before
up.
we do, I'd just like to say a massive thank you to Hannah for that really good oversight. I'm sure everyone's brain is fizzing with questions they can ask their data controller within their organisation about how to help the charity. If you are unclear of anything, or if you wanted further information on anything, while it's fresh, pop it in the chat, and we will do our best to come back and answer as many of the questions as we can. Yeah, massive thank you, Hannah. That was really engaging and useful. Thank you. And now on to Matthew. Matthew, the CEO of the Institute of Legacy Management.
I thought it would be helpful to give a bit of context to this because I've been in the charity sector 26 years now, and there was a real problem. Oliver, if you'd like to jump on. There was a very real issue prior to GDPR, and in general, there was a very loose attitude to supporter data. And I remember being sat in meetings with people where very senior fundraisers were explicitly saying, how can we just claim everybody's opted in? How can we overcome these objections? There were, these regulations and the way data is addressed now did address a very real problem and a very blasé attitude to supporters and what they might have wanted. Oliver, if you want to move on. The canary in the coal mine was the Olive Cook issue, which some of you may remember, but basically it emerged that this elderly woman, Olive Cook, had received thousands of charity appeals, and her family and her were repeatedly contacting charities asking to be removed from the mailing list, and were just being ignored, basically. Requests to delete her, all of that were just ignored. And in the end, and it's very unclear. The causality is very unclear, but she took her own life, and there was a widespread view that the attitude that the charities had taken was a contributory factor. And you can see the two aspects of it here. Do go off and look at them. They are fairly grim. The Daily Mail took a very strong line that essentially the charities were wholly to blame. There is a more balanced view in the second one down. Sophie, I can't remember what that stands for, but they're a well-respected organisation. They did a deep dive into it. And the truth is they took a more balanced line, but it still makes very grim and upsetting reading, actually. And there was a strong undertow of contempt, both for her and for supporters in general. And so you think this didn't come out of nowhere. There was a real problem, and the kind of modern data retention policies were in response to that. So do go off and look at those for a cautionary tale of how bad it can get if this stuff isn't taken seriously. Oliver, I think, do you want to? Self-regulation failed. It failed catastrophically. And there was no way that the charity sector was going to avoid external regulation. And the fundraising regulator came out of that, and their guidance, and GDPR was massively informed by this. And charities did respond to this very responsibly, adopted a much more ethical approach to supporter data, introduced much more rigorous opt-in, opt-out procedures, and a lot of charities brought in what were at the time considered to be kind of very risky approaches to kind of active opt-in. A lot of charities said that you basically had to absolutely contact them and say that you wanted to opt in before they would mail you. But I do think over time this has become quite mechanistic, and the pendulum has probably swung too far in the other direction. I mean, that's very much a personal opinion, but I think the kind of automatic deletion at 6-7 years, all of those sort of policies you can see how we ended up here, but I'm not sure that we can't now, with the culture change that has taken place, adopt a much more nuanced attitude to this, particularly in the context of legacies, where it can take, a very long time and be a process of a very long and kind of cultivation process with multiple touch points across the charity. So, this is why we're here today, James and I, because I think we do want to get across the message that you need to be more sophisticated than simply automatically deleting people, and need to take a more intelligent view, and that actually the culture change has worked. I've seen nothing in recent years that indicates to me that charities are anything but scrupulous with supporter data. And so I do think we can afford to take a more proactive and nuanced view, as Hannah said. So is there another slide, Oliver? I'm not sure. So there you go. When and what to keep. James, do you want to pick this one up?
Yes, I can do. Obviously, the truth is that a 65-year-old is, the most common age of death is 87. People are going to make and interact with you around that will writing, or potentially just they're giving a long time before they die and a long time before any claim might come up. So keeping that data is very, very helpful. Yes, it can. We know we've got cases where, personally, I don't think the judiciary should place as much weight on a gift of £5 20 years ago, but they do put a bizarre amount of weight on that, and I think there is a very legitimate interest in keeping that. I personally have a view that 45% of income from Macmillan, and I think it's 30% for the sector, comes from legacies, and actually understanding the supporter history of people who go on to leave legacies is vital. And I think as long as you are respectful of how you keep that data, you can keep quite a lot of supporter data and really push that legitimate interest to say, well, look, 45% of our income is coming through legacies. We want to see which supporters go on and do that. So, I think this last point is also going to be quite interesting. What we don't know is how the changes to the Wills Act, if they're implemented, around discretion and dispensing powers will impact. But there's potentially a more litigious environment around probate generally, and this kind of evidence, I think, could very well be more important. And I think ultimately, if you're holding data and being respectful with it, and you're not writing out and using it in ways that you don't have a legitimate interest with, you're good. And I think there are, Hannah's alluded this, there are powerful reasons to retain. You've got to be a bit imaginative and set out that case, but set out that, legacies are hugely important. Legacy income is hugely important. And this data can be helpful to you both for understanding the journeys that people have been through and for this defence against claims.
Thank you very much indeed, James, and thank you very much indeed, Matthew. That was really useful, and we'll come back to you later on in this session with your more information about the fact sheets and support that ILM can provide. Everybody, not just members, but obviously being a member is great. Again, a call out if anybody has any questions for James or Matthew or for Hannah. Please do chuck them in the chat. I thought of something when we were running through for Hannah. I'll just throw in there. Everyone, please do feel free to pile in. But now I'd like to hand over to Marie to talk about a short breakout session we're going to take to give you an opportunity to have a little conversation with others who've taken the time to attend, and also find a little bit more about what you know about your own organisations. So, Marie, are you ready?
I'm ready. So I'm going to create some breakout rooms and send you all away into them. So if you want to try and find your data retention policies and have a look at it and have a bit of discussion, and then we'll come back after about 5 or 6 minutes, and then we've got a poll for you to take part in. Okay, so I'll create those now.
And if you can't find your data retention policy and no one's ever told you where it is, that is a point of discussion in of itself. See you all in a hard 5 minutes, 31 minutes past. We'll call you back in about 4, so that gives them a minute to calm down and pile out. Why don't you tell us about the interesting conversation that you had within your room, so that we have want anyone else, and then
two things came out. First was, it was absolutely the classic that it was on the to-do list but never got done. But the second was talking about like records on first class, essentially going back 25 odd years or 20 odd years, which weren't obviously being used for anything, but which had never been deleted. And you think, you know, okay, yeah, and I mean, I'm familiar with that from when I worked in a legacy team. It wasn't a kind of being kept on spec. It was just like, actually, it would be a job of work to get rid of them.
I would chip in here on this one, because actually Macmillan worked with Clear, who produced First Class, and we have deleted around 50,000 legacy records. So ironically, I'm saying keep all supporter data of everyone alive, because I think that's going to be really interesting to see their history and if they do go on and leave a legacy. But actually, after 6 years after you've received your legacy, you should be getting rid of that stuff. Ultimately, there's a lot of correspondence history, a lot of information. You don't need it. If the executor finds something, you can go and get the will. We've deleted all these records and we haven't lost anything. And I think it is the right thing to do, because there's a lot of personal information around people other than the legator. So get it off that to-do list, get in touch with Clear. It's not actually that bad, that process. And I do think there is little justification for keeping old legacy files as opposed to your general supporter data.
Yeah, I should add that GDPR actually only applies to living individuals, but of course, if you've got records that do contain data of other people that are alive, and there's still confidentiality obligations that would apply to that data.
Yeah, and I sorry, but you're right, Hannah, because what I'm actually not saying is don't delete the name and the details of the but on First Class, you've got various fixed fields, so keep the name of the supporter and the information directly about the supporter and the legacy, but any free text and any correspondence should go. We keep the sort of pure legacy record because it's not covered by GDPR and is helpful for historical mapping, but all that correspondence, I think, there's no real reason to have it.
Marie, have you had
any luck
with that
poll? It's coming. Super. It's coming. I'm so sorry. Right, save as meeting poll. Oh, that's what I did before. Loading, sorry.
Yes, it's one of those things that was there until you did the breakout room and then it immediately deleted itself. Sorry, everybody.
Anyway, so we have it now. We're here. So I've launched it. So if everybody can take a look. That would be great.
There's 7 questions. Let's give it a minute for everybody to answer so that we can then have a quick debrief and see how everybody's doing, see if there are any trends that we need to be aware of. Okay, 10 more seconds. Super. I'll just talk through the results that we're seeing, and then I'll end the poll. It'll share with everybody. looks great that everybody who's answers knows where the data policy is. Now, that's not always the case, and I'm really, really pleased to see that it is. Maybe the people who haven't answered didn't want to answer that question, but hey, there's less clarity. We've got more than half of the people who responded saying that there's no clear guidance on how long to keep information around people who have confirmed to have pledged a legacy. The overwhelming majority believe that there is effective legacy stewardship within the current policies, and most people do not think that their policy creates any barriers or frustrations, but an alarming a quarter of the people who've answered thinks that they do, and those are the people who I hope are going to go away and have the most constructive conversations after this session. We'll touch on why it's going to be increasingly important as the law evolves in a minute. Do you know who in your organisation is responsible for reviewing or updating? 90% yes, 10% no. It should really be on the policy. So if there is a gap in your knowledge there, if you don't know who to speak with, that's a really important question to take to the top. Everybody would be comfortable to raise any concerns, and over a third of people think that the policy should be updated. I'm going to share that with everybody. If you want to grab any of that information, if you want to kind of take it away, just to, if you feel like you're on your own in an issue, and you can see that there's 10, 15 other charities in the same position, it might be quite useful information to take when you have those discussions with your data monitor. Thank you everybody for responding to that poll. I'm going to stop sharing now. If you've any questions about that, I had another question in the chat from Phil. We've just mentioned the data retention policies and deceased people. GDPR, to be clear to the person who raised the question to me, does not apply to people who have died. GDPR may well apply to other people in the family of the deceased, though, so be alive to that. Other beneficiaries, the executors, and so on, who you may not have any good reason to be holding onto their data. And as James said, once you've had a gift from that will after somebody has died, there's no reason to keep that correspondence after a reasonable period. So
can I just chip on, Oliver, on that? Because I think it's interesting. Legally, they don't have that GDPR doesn't apply, but I think sort of mentally and morally, people might, sharing information publicly about that donor you do need to be nonetheless respectful of those others. It's an interesting way how you navigate that, because it's not clear who you actually have the conversation with. But legally okay, but interesting practically.
Yeah, and if you consider how cross people often get when they discover the existence of the SME and Ford service, and lay executors in particular will often be, how did you know and what's going on? Even though a will is a public document, you can see that there is an expectation of privacy. You can see that there is clearly in the public mind, in inverted commas, an expectation that this is sensitive private information.
Absolutely. And I can see there's a few other questions in the chat, and we'll come back to those. Come back to those after I have a word with you all around just some horizon scanning, some stuff which here we go, some stuff which is bubbling away in the background about something which is going to affect everybody's work if it comes to legislation. So there's a new draft wills bill which has been published by the Law Commission, and it's been considered by Parliament. And I'll come to how far through the process it's got in a minute. But I wanted to have a quick chat with everybody here. I'm Oliver Asher, founder of Make a Will Online. I'm also a solicitor, and I've had a number of really good conversations with people up and down the country about the new draft wills bill. The Law Commission, this is the third time in my career the Law Commission has looked at wills, and it feels like the current laws, which are all related to the Wills Act 1837, are looking increasingly tired. We're in an era of digitisation. People's behaviours have changed massively, and their expectations of how they're going to be making wills are not the same as they would have been 10 years ago, 20 years ago, and definitely not back in 1837. So we have a draft bill in circulation to fundamentally change the way that wills are made. What's that got to do with GDPR? Well, I'll tie that back in a minute with some of the changes they're doing. So this is a nice little screenshot of the original. Thank you, Queen Victoria, for signing this piece of legislation. And that is actually what you get to look at if you go into the legislation archives. Still law. That's Kaiser Wilhelm. So this law is older than the formation of Germany. This law is older than the Restoration period in Japan. There were still samurai wandering the islands of Japan when this bill came out. And it's before the formation of modern America. It's really, really old bit of legislation. It does need changing. So what the Wills Act 1837, some of the important stuff that everybody who deals with wills has to consider, which goes back to 1837, points around capacity and undue influence. It's assumed that people know what they're doing at all times when they're making their will, and there is a peculiar set of legal rules to make sure that somebody has capacity. It runs to a very, very old, very old case called Banks and Goodfellow. There's some really strict rules about how to witness a will, and if someone has capacity and if it's witnessed in the right way, then the will becomes legally binding. If either of those things fail, it doesn't, even though it's patently obvious what the person wanted to happen. There's a peculiarity of the Wills Act that means that if you get married, all your previous wills are cancelled. So if somebody leaves you a legacy, makes a pledge, that then they get married, even if they wanted to make sure that your charity was going to be supported in the future, that gift would definitely fail. And there's also some really strict rules around terminating wills, cancelling wills. They've got to be destroy the will yourself with the intention to revoke it. And if you fail on that, or if you get somebody else to rip it up when they're in a different room, then the will remains valid. It's ancient and it's unjust. So Wills Act, draft wills bill is coming into force. So let's have a look and see what is going to change and what that means for charities and what that means for your obligations, or what you should be, the conversations you should be having internally around GDPR. Before I go too deep, I just want to say how early in proceedings this draft bill is. The Law Commission published their reports in May, and there was a lot of news about it. Everyone was saying, hurrah, end of the new Wills Act. It's got to find its way through both houses of Parliament, and it is not very far through. The draft bill was published in May. The government promised to look at it within 6 months. That 6-month deadline was 10 days ago. And they still haven't looked at it. It's not been slated for discussion in the lower house. It's not been slated for discussion in the upper house. Once it gets through the House of Commons, it's got to go up to Lords. Once it gets through Lords, then it goes back to the House of Commons again, and it has a little repeating cycle. So even if it gets slated for discussion, it doesn't mean it's going to turn into an actual law. And by gosh, does the government have lots of other priorities at the moment? But let's see. Now, what is this draft Wills Act going to do? It's going to get rid of the old Act, but it's going to copy across some of the parts of it. But importantly, it's going to widen who can make wills. So anyone over 16, my suggestion is, should be able to make a will, and that's great. Don't know how many gifts in wills 16-year-olds are going to want to give, or how big those gifts could be. It's also going to widen that right to people who are under 16 if they show that they've got capacity, and anybody who's got a friend or family member who's faced a childhood bereavement will understand how important that is emotionally. So that's going to be available. The rules around capacity are going to change. So the much loved Banks and Goodfellow case from 1871, I think, that's out the window, and the Mental Capacity Act is going to apply. That's fine. It just means that instead of people knowing about what's in a will, what's in their estate, and what's who would expect to inherit, people are going to have to show that they understand what they're doing, be able to retain information, be able to use the information that they've retained to reach a conclusion on why they want to leave a gift in their will, make their will, and then communicate that. Slightly different, have a legalistic difference. The big one for you is going to be the powers of the courts to determine that someone had a testamentary intention. At the moment, if there is no executed will, then there's no gift. After this, if the courts are satisfied that someone has testamentary intention to leave a gift in their will, then there can, and there probably will be, an argument that that is that should be held, and the charity should benefit from the estate of the deceased, even if they did not correctly execute their will, or even if they did not remember to complete it. I think there's going to be a lot of case law. Watch it carefully, because your charitable duties to ensure income to the charity, which I'm sure Matthew will be able to, and James will be able to better describe than me, they may well be affected by this. So knowing that somebody wants to leave you a gift is going to be increasingly important, and whether they communicated that to you yesterday or 10 years ago. So this 6-year retention schedules, I hope, will become a thing of the past for all of the charities, for anybody who's still running to them. Matthew mentioned Olive Cook, so I'm going to mention Olive Cook. Undue influence. The rules around undue influence are going to change. At the moment, if you want to say that somebody was made to execute their will when they didn't really want to, but they were being unduly influenced to do so, you've got to prove that there was undue influence. Under these new rules, the rules are flipped on their head, and if someone says there's undue influence, then the executive is going to have to prove that there wasn't. No more revocation on marriage, that's a suggestion, which is good for the charitable sector. Societally, I don't know quite what effects that's going to have. And well, here we go. If somebody just scrawled on the will and didn't get it witnessed, etc., the courts again are going to have increased powers. They e-signed it rather than signed it on paper. Again, courts can see if there is testamentary intention. And finally, e-signatures. There's going to be a lot of chat about that. Nobody knows what it's going to look like. Technology is evolving very, very quickly. My only hope is whatever the statutory instruments that come off the back of this are, they're going to be clear for everybody, because believe me, as a legacy fundraiser, you are going to be asked. And as with anything, if it's a question of a legal nature, bat that up to a provider of legal services, a solicitor, an estate planner, and don't rely on what the situation was 6 months ago when you last checked, because it's likely to be fast moving. So there are likely to be e-signatures going forwards. So as a wrap up for legacy fundraisers who are trying to do their legacy management's good solid going forwards, make sure that all of those conversations around gifts and wills are recorded. They are going to be relevant. They are going to be pertinent in the long term. And if this bill becomes an act, then those records are going to become increasingly important as people say that if someone with an executed will had demonstrated a testamentary intention that they wanted to remove that gift, you will have an argument. And B, if somebody showed testamentary intention and something happened, they got hit by a bus on their way to sign their will, then you will have a legitimate claim in order to see if you can get that gift, ensure those supporters' wishes are actually filtered through to the charity, despite the lack of a will. So that is, if anyone's got any questions, as ever, please do pop them in the chat, and we'll deal with that in the wrap up. But sorry, one more thing. It's going to allow an update to the CPRES rules. So if somebody leaves something to a non-charitable body that then goes ahead and incorporates, or a CIC arm of a charitable institution, then that is going to have different succession rules to the current. So that's the end of my bits. And time for the wrap up. And I think I'm going to hand back over to Hannah, James, and Matthew for that.
I don't know if Hannah, you're going to kick off on that first point, are you?
Yeah, I think hopefully today has enabled people to kind of understand a bit more about the legal background and what flexibility and nuances there can be in this. It doesn't have to be kind of a fixed amount of time and then deleted forever. So I think if you have got concerns about your current data retention policies and some of the limitations that might be putting on legacy fundraising and administration, then definitely have those conversations in your organizations, and think about how you could take a slightly different or more creative approach, which kind of is compliant with data protection law, but is also achieving the best possible outcome for the organization, and is boosting income as much as possible.
Yeah, I think that's definitely right, isn't it? It's organizations, you've got to be respectful of data, but you've also got to look for the opportunities of that data, and you're doing a good thing, and if something is going to allow you to do more of a good thing, it's worth trying to find a way. So be confident and express that benefit. If you particularly from a legacy administration, we're going to send round a link to the ILM fact sheet, which was something I wrote a few years ago with the help of Hannah and a few others. It does, as you'd expect, mainly focus on the legacy administration data. Please have a look, and if you've got any feedback and not sure, get in touch. But
what I was going to say with regard to the ILM fact sheet is, if you're not an ILM member, our system is not going to let you access our fact sheet. So what I was going to do is send it to Marie, and she can send it around with, I assume you send around the slides, or I will send it to Marie and she can make it available to all of you nice people who've turned up. But you really should consider becoming ILM members.
It's slightly concerning that we're just sort of sending that into the ether with me as my fact sheet, but hopefully it's good and worthwhile. I think it is. I spent a long time doing it, we'll send that around. Yes. But I think that's the main thing. I think what Hannah's just said is really that crucial thing for as a next step for you.
One thing I want to say is, if you are having conversations internally, and you or your colleagues feel like you need more information is available. Nobody who's attended this this seminar is going to be an expert at the end of this. Some people, a little knowledge is dangerous. there is a resource in the ILM. Use that. If you have an educator, or if you can't get the proper answer for your particular circumstance, then do contact a bona fide expert who does this for their day job, Hannah. We're going to circulate your details for those. It's probably going to be quite rare, but when you need an answer, it's worth getting a reasoned legal opinion off the back of it. So resources are there for you to resolve those areas of confusion, because every circumstance is different. And I think that's
there's a few
draws us to an end.
questions. I think there's a few
super.
questions in the chat.
Come to my one last, if you would agree.
Oh, there's a long one. So from Emily Webb, as a university, we already have supporter information and contact preferences from our alumni database. We then receive GDPR comms opt-in or opt-out from Makeable Online regarding the legacy they have created. Does a Makeable Online GDPR opt-out of contact supersede our communications opt-in? Does this mean we can't process the fact that they have left a gift whatsoever, so can't be added to our legacy society, and should keep receiving legacy acquisitions material go into the grey area where they receive neither? So, Oliver.
Can I pin on this, because it's a regular question, and then Hannah, please do add additional if necessary. If you have information on your supporter, that is yours. If we provide you with information on your supporter and say that they don't want to be, they don't want a conversation about this with you, i.e., when they go through our system and make a will, then you wouldn't, off the back of the information that we've provided you, be able to put them onto the legacy society information. But you do have that information. They know that we're going to send you that information. So you'll know that they are a legacy pledger if they left a gift in that will that we gave you. Put that on the record, but don't contact them about it. If in 5, 10, 15 years' time there is a dispute, then you'll be able to show that longitudinal relationship with them and their intents at the time that they made their will. Emily, does that answer your question? And has anyone else got anything to add to that about information coming in from different sources and GDPR?
Yeah, that answers my question, Oliver. Thank you. Can I ask, just off the back of that though, if because these are people we have kind of regular contact with, at a later stage, if they bring it up to us, I suppose that then supersedes that opt out, and then we can then kind of process it as normal.
Yeah, absolutely. I think often people click the no button by default, and then if they come along and have a legacy conversation with you after that, that's great. If they've had a legacy conversation with you beforehand, you'll still know that they were a pledger if that was the stage that they were at. You just won't be able to. So you'd still know they were an intender if that was the stage that they were at. You just won't be able to put them onto the pledger list because they've asked you not to via us by the information that we provided. Great.
I think it's your question now, Oliver.
Oh, super. So I had a question for Hannah. You, in your piece, you were saying that when you're looking at kind of justifications for retaining or getting rid of information or processing information, everything has to be on an individual basis. And I touched on that as well at the end as well. When you say individual basis, do you mean per person, so it's completely granular, or do you mean per greater classification?
Yeah, I meant the latter. I think it would be impossible in a large database to be going into every record and looking at it very carefully. So yeah, it would be more about what's your organizational approach. And so, as James was saying, you might look at something after a certain amount of time and think, okay, we're going to keep, for this set of people, we're going to keep, the core record of how much they donated, whether they pledged legacy, etc. Anything that's useful information. Anything else, we're gonna delete. So it's just about having a system for reviewing rather than just having a policy which you kind of never do anything with again.
I've just seen the time, and we've gone. It's now past 12. I think Marie's going to give a little bit of information about the next session. But before she does that, I just want to say an absolutely enormous thank you to Hannah Lyons from Bates Wells, and to Matthew from the Institute of Legacy Management, and to James, ILM, and Macmillan for giving up your time and for doing such a wonderfully engaging session. Really, really great. Any questions that people think of off the back of this, please do email us at contact@makeawillonline.co.uk. And I'll now just hand over to Marie for a very quick closing and information about the next session in the new year. But huge thank you to everybody. Thank you.
Thank you, everybody, for joining. Hope you found that useful. Our next Legacy Loop is going to be on the 10th of February. We've got Richard Radcliffe, who will be joining us for a session on the changing world of legacy giving. So I'm busy organising that. Once I've got everything set up, I'll send out the invitations. Obviously, I'll send out all the resources from this session to everybody, the link to the recording, the slide pack, and also the ILM fact sheet. So thank you very much.
Brilliant. Thank you everybody for giving up your time to come today. All the very best. Cheers.
Bye.
Thank you. Bye-bye.
Bye.
Thank you. Bye.